quite extensively to page 18 of your affidavit. And you, in your evidence, your oral evidence and in your affidavit, you contest the fairness/lawfulness of your dismissal. I don't intend to debate that with you today because it's not for me to decide whether or not you were fairly or unfairly or lawfully or unlawfully dismissed. Neither is it the focus of this honorable committee with respect. It's a matter for the courts. Now, when we last left off, I'm not sure at which point, you had indicated that your matter was on appeal to the Labour Appeal Court. Now, Chair, can I just again check whether, honourable members, whether you have a copy of the Labour Appeal Court judgment before you? I think it was posted online, but you may not have a hard copy in front of you. Sorry? I think General Phahlane has attached it. And so it's in the supplementary bundle. Where is it?
Page
15.
1050.
It's at page 1050. 1050, it's annexure JKP 17 in brackets capital E. And that the matter was argued last year in November, and the judgment was handed down on the 5th of February. And as honourable members will see, and General Phahlane will be aware, it's a quorum of 3 judges. And the end result was that the appeal, General Phahlane's appeal, was dismissed by all 3 judges. They differed, however, in as regards the basis on which they dismissed the appeal. Acting Judge of Appeal Tokota, he found that the court didn't have jurisdiction, or the arbitrator and the Labour Court and the Labour Appeal Court, and for that reason had dismissed the appeal. The other 2 judges, they dealt with the merits of the appeal. They did not agree with Mr. Acting Justice Tokota, and they gave their own reasons why they dismissed the appeal. Nkuta, Justice of Appeal Nkuta Nkotwana, and Justice of Appeal Chetty wrote separate judgments, but they agreed on the merits, and that appears from page 1099. General Phahlane, if you wish, you may comment. You have indicated that you have now sought to appeal your matter further to the Constitutional Court.
Thanks, Chair. I will first deal with the incorrect reflections of this evidence leader. First, the matter served in court on the 16th of September 2025, not in December. Where it's coming from, I don't know. Secondly, I will deal with what is referred to in my affidavit that we have already dealt with. If Chair, just give me a chance. Evidence leader is saying, I have dealt with the unfair dismissal from page 11 to page 23, which is incorrect. I only deal with the dismissal issue for specific reasons from page 11 to page 18 of my affidavit, which is under paragraph D. Paragraph E onwards deals with the procurement contract. If you visit that judgment, you will realize that very little of what was raised is being dealt with. But Chair, you had 3 judges, they have pronounced, and it's part of our system. And we must all respect the courts. The evidence leader, if he perused that judgment, he would have found that Judge Tokota found the dismissal to be unlawful. And the reason why he's saying it's unlawful is because of the players who played a part who are not by law authorized to act. And he simply says it's dismissed because he say unlawful dismissal falls outside the jurisdiction of the labor court. He say it would have been relevant at the labor court if it was unfair dismissal. On the unlawfulness, all the 3 judges agree. But the other 2 say, let's zoom in on the unfair dismissal, which is Judge Shetty and Nkuntwana. I can't remember the other surname. And all 3 ultimately agree on the dismissal of the application, and the judge who communicated, and it's even written in their judgment, they have agreed on the dismissal of the appeal, not necessarily on the reasons. They reason differently. Now, Chair, I have said it's a matter which is now before the Constitutional Court. And I don't want to deal with issues of the judges here. Later I'll be accused. Respectfully, I'll request that this matter, I have communicated. It's me who provided this committee, the Honorable Committee, with the judgment. And I was providing it for transparency purposes to say, here is a process which we have spoken to. This is the outcome. And now I'm recording before the Honorable Committee members that we are now in the Constitutional Court. That's how far I can go with the matter, Chair.
Honourable Chair, again, just for the record, at paragraph 76 of the judgment, at page 1072, Mr. Justice Chetty takes issue with the reasoning and the judgment of Mr. Acting Justice Tokota, and says, I'm not persuaded by the correctness of the argument, with the argument being that the arbitrator exceeded his powers by referencing acts performed by General Phahlane while he was the acting National Commissioner. Because essentially, the General Phahlane's argument was that as acting National Commissioner, I could only be dismissed by the President. The two judges who disagreed with Mr. Acting Justice Tokota said that the acts complained of and in relation to which General Phahlane was charged was when he was the head of forensics, and it was entirely appropriate for him to be dealt with under the disciplinary powers of SAPS. And that you'll see at pages 1072, 1073. So all I want to do and wanted to do was to place it on record whether General Phahlane put this judgment before us, I think on the same day when the judgment was released. I forwarded it to the parliamentary legal team to make available to honourable members. So it would have been here, but he's right. He's done well to make the committee aware of this judgment.
Chair, may I make my last comment on this? The matter is in the Constitutional Court, 1. 2, I don't think it is fair for the SC, for that matter, to be selectively going to the judgment. The same Judge Chetty say, when the charges were brought, that 72 that the SC is referring to, somewhere he's saying, you can't say you should have been dealt with by the President because when you were an acting National Commissioner, simultaneously you were performing duties as the Divisional Commissioner for Forensic Services. Now, it's just too foreign to me. When I'm acting here, an acting Divisional Commissioner is being appointed by law, not by choice, by law. Now, I don't know why I must be answering to the evidence leader on a matter which even the question itself misrepresents the facts contained in the judgment. And I don't think I've got too much time at my disposal to go through each and every one of those arguments, including reliance on information which is found nowhere in the records, which is part of the Chetty judgment. And all those things we are dealing with in the Constitutional Court. I'm glad I'm well represented. I don't have the appetite, Chair, to go too much into that matter. The lawyers sitting behind me are dealing with that matter, and I believe they are competent to do so.
General, is it so that your dismissal relates to the issue of the ITMA tender award and the irregularities that arose in that process as a result? Rightly or wrongly, can you just give me a yes or a no?
I'm not going to give a yes or a no. Which irregularities? Because the irregularities are actually mentioned by me in that process. There is no irregularity that I'm party to in this regard. If you just read the judgment itself and you read the submission which is here, I think in part D of my affidavit, there are no irregularities that I'm involved in. The only thing that I was accused of, which I'm saying I am not party to that, is the failure to cancel the contract. When the issue was raised with me, brought to my attention by supply chain management, having received a complaint from a service provider, 22nd of August 2014. I responded on the 22nd of October 2014 that the contract should be cancelled. Supply chain management was to follow the process that they were to follow. That never happened. And subsequently, ITMA lodged a claim. Having lodged a claim in 2018-2019, I was here explaining it, that in 2018-2019, when I'm no more in the system, 30 million rands get paid to ITMA, not by me. So I don't know which irregularities you, senior counsel, is selectively referring to. I've got no irregularities involved in this regard.
The honourable members will read for themselves from the judgment of Acting Judge of Appeal Tokota, because that's the one thing that the two other judges agreed with, is his setting out of the facts. And that appears from page 1052, paragraph 3. And the facts are set out until page 1055 at paragraph 20, when you were suspended on the 1st of June 2017 by the then Minister of Police. And the point was not, which is the one that you tried to make with respect, General Phahlane, that you found an irregularity with the award to ITMA. The point that is made in the judgment by Acting Justice Tokota is the ones on page 1054 at paragraph 16 on 25 April 2016. The Managing Director of ITMA wrote a letter to the Acting Divisional Commissioner for Forensic Services, Lieutenant General Mokwana, and proposed a joint meeting. On 29 April 2016, the Acting Divisional Commissioner Forensic Services, Major General Nkoka, addressed a letter to the Divisional Commissioner Supply Chain and recommended that in view thereof, the two divisions were not in agreement with the award and that the matter should be referred to the CSIR for independent assessment. Paragraph 17, on 14 July 2016, lawyers for ITMA served the appellant in his official capacity as the Acting National Commissioner for SAPS with notice in terms of 3 of the Institution of Legal Proceedings Act, informing him that ITMA has accepted the repudiation and thereby cancelled the contract and would claim damages. And the reason for that, General Phahlane, is that despite the award of the tender, which had not yet been set aside, and we know it can only be set aside in a court of law once awarded, was that you were not issuing any purchase orders, and of course by then you had left to take up the position as the Acting National Commissioner. Paragraph 18, on 29 September 2016, the Forensic Services Division received a letter from the National Treasury advising it to request the SABS for scientific and industrial research to independently verify compliance with the specifications. And then on 30 September 2016, you in your official capacity as Acting National Commissioner was served with a summons, and then subsequently you were suspended. You will know from the events that unfolded that as a result of what is alleged to be your negligent, reckless conduct. SAPS had to pay damages in that amount, 14,879,000. That is that went to an arbitrator. In fact, it's recorded by Appeal Judge Dakota at paragraph 22. The arbitrator found, that is in relation to your dismissal, both substantively and procedurally fair. The arbitrator found that it is common cause that on 14 October 2015, the applicant was appointed as National Commissioner. She found that although the appellant claimed that at that time of the case, sorry, I can't make this out, he was no longer in charge of the division as the overall head, he ought to have found out what was happening in the matter. The arbitrator found that the accounting officer, as the accounting officer, he had the responsibility to find out what was happening with the contract. So, and the two judges found that reasoning to be sound and fair, and on that basis, the judges found against you. So, you're going to appeal to the Constitutional Court. We know that that's going to be a hard row to hoe, but as you say, you've got competent lawyers acting for you, so good luck. Now, unrelated to that matter, there are also two other contracts in relation to which you currently face charges, criminal charges. If I may just check, Honourable Chair, whether those documents have been made available yet, and whether the witness has a copy. So I want to refer to the two charges which General Phahlane will recall at the last hearing. There seemed to be some lack of clarity, can I put it that way, or uncertainty, whether you're in fact facing criminal charges. So let me deal with the first one for your comment. The matter that's in the regional division of Gauteng in the Specialized Commercial Crime Court, the case number is SCCC/265/2018. Have you got, you'd be familiar with the charge sheet. You are accused number 5. And I believe these charges, the NPA intend to prosecute later in this year, October, November. Can you confirm that?
I cannot confirm what I don't know of. First, Chair, reference is made to do 2 audit reports. Where are those reports and what do they relate to?
I'm going to come to the reports. I'm dealing with a charge sheet.
No, Chair, I can't allow a situation where we are not on the same page. I'm being asked a question to respond to on things which has got nothing to do with what is being asked. You must separate the two. The 2 reports that he's referring to, Chair, are SNG reports. They've got nothing to do with the matter you are referring to of the Pretoria Specialized Commercial Crimes Court. The matter of the Specialized Commercial Crimes Court has to do with procurement by crime intelligence on software which was used, successfully so by the way, to police the fees must fall challenge that the country was faced with. Secondly, that software was used to deal with the Vuwani unrest and the banning of schools that took place in Vuwani. So there is no relationship between the reports that the council is referring to, unless he's got the secret reports that I don't know of. And the issue that he's referring to, it's actually traversed in my application, where I think towards the end, not in my affidavit, if I can just check so that I can make reference to it.
So if it's in your affidavit, you've put it in before this honourable committee and it's relevant.
Chair, I was just trying to even get some clarity so that I can be able to deal with the thing. All I'm saying, in as far as that is concerned, is that the evidence leader is putting two things together which do not belong to each other. First, he spoke about the reports and say, these reports, based on these reports, you are facing criminal charges. And now I must ask, show me the reports and which criminal charges. Because even those reports that you're referring to, there is not a single criminal charge. And those reports are not part of my affidavit because they've got no relevance.
General, do you accept that you are facing a myriad of charges? In fact, I'm counting from the 11 accused, of which you are accused number 5, 192 charges before the Special Commercial Crimes Court, ranging from fraud, corruption, and other charges. You would have seen the charge sheet. Are you facing these charges or aren't you?
I'm not going to answer if you are asking me irrelevant questions, and I'm trying to explain to this committee that, Honorable Chair, I'm being told that there are reports based on which I'm facing charges. First issue that I'm raising is that the reports are not even here with me. 2, I'm saying those reports have got no relevance here. 3, I'm saying, and I'm clarifying, and that is one of those cases that I said, let's go to them, because this was said when I was here, you are facing a myriad of charges. Now, I said there is a case related to the software procurement by crime intelligence, where my role is solely to have provided a deviation according to the laws of this country. That's the charge, the case that I know of. As to your 190-something charges, which I don't know of, you may have to allow the NPA or whoever concocted those charges to traverse those at the Special Commercial Crimes Court, where I am going in October, November. And I'm going to be dealing with those. And lastly, those charges, Nkabinde was here, was telling you about what had happened. Those are the charges that are flows from instigation by Paul O'Sullivan and Robert McBride, who were here. If you look into the affidavit of the particular case, that, what is it, A1, it's by Nkabinde, half a pager, who is saying, we have received information. That's not even the elements of crime in there. He goes further to say, he knew that there was nothing. He was pushed to go and open those cases. That's why they are going to populate all 192 which you say you have that have got nothing to do with me. Part of it is that I'm sitting on the bid specification committee, bid evaluation committee, and the bid adjudication committee. I do not have the honor or never had the honor of sitting on any of those committees. If you peruse those charges, some of them will say Phahlane was sitting there. So I'm clarifying it, Chair, that there is this case. And this is the case I wanted to talk to when I said there are 3 cases. Before the Pretoria Specialized Commercial Crimes Court, which will appear for trial, by the way, October, November this year.
So, General Phahlane, why did it take so long for you to acknowledge and accept that you are facing these charges in October, November? You will appear in court. You do not agree with these charges. You contest them, and you're going to defend them. Why is that so difficult?
It is not difficult. It is difficult because you are feeding this committee with wrong information. That's the difficulty.
Now,
and that is what I'm trying to explain.
Okay. Instead of being accused, or rather than being accused of feeding the Honourable Committee with wrong information, let me read to you from the charge sheet. And you will be familiar with this because you must have seen, and your legal team would have seen this. Manipulation of the procurement process. Accused 5 was appointed as Acting National Commissioner of SAPS 14 October 2015 until he was suspended in 2017. As Acting National Commissioner, he was also the accounting officer of SAPS. On 19 October 2015, 5 days after assuming the position, accused 5 withdrew a circular referenced as 19/1/1 and dated 23 March 2010, which required that all bids of over 500,000 be processed through the Office of the National Commissioner. Accused 5 instead appointed the Divisional Commissioner for SCM as the chairperson of the Bid Adjudication Committee of SAPS and empowered the BAC to award contracts above the threshold value of 500,000. And then it goes on to detail the extent of this manipulation, deals with the decision to jettison the NT transversal contract, the SAPS contract to procure emergency equipment for SAPS vehicles had expired in 2015 and no contract had been in place. National Treasury had in place a transversal contract for a procurement of emergency warning equipment for emergency vehicles, including police vehicles.
Sorry, Chair. May I be allowed to say something?
Are you done reading from where you were reading?
No, Honourable Chair, I'm guided by the directions of the Chair. This is not a court of law where I can object.
If you can,
I'm not done yet.
yeah.
Rather than
if you
being
can conclude the part
yes,
that you were reading
yes.
and allow him to say something.
On the 12th of August 2016, accused 5 signed a letter addressed to the Chief Director, Transversal Contracting, concerning the supply and delivery of ambulance, rescue and emergency equipment and accessories for the period 1 April 2015 to 31 March 2017. Accused 5 stated that SAPS was in the final stages of finalizing the specifications for emergency equipment. And this is your topic, General Phahlane, blue lights, and had decided to establish its own contract for blue lights. On 19 August 2016, accused 1 wrote a letter to National Treasury requesting National Treasury to expand the meaning of emergency and or urgent procurement to include cases of emergency. On 19 August 2016, the Chief Director, Transversal Contracting for National Treasury responded to both accused 1 and 5 and granted SAPS permission to establish its own contract for procurement of blue lights. Then there's reference to the 2 abandoned procurement processes. Then there's a subheading, again set out quite in length, manipulation of the specifications. On 8 August 2016, Lieutenant Colonel Bunzaya was contacted telephonically, first by accused 12 and then by accused 5, who both instructed him to meet accused 10 to assist him in bidding for a portion and the complete SAPS National Emergency Blue Lights and Siren tender. Accused 5 requested Bunzaya to contact accused 1 and 12, provided Bunzaya with a telephone number for accused 1. Bunzaya met accused 1 at the SAPS Academy, Pretoria West, on the same day. So, and then there's reference to the 3rd procurement process, which I'll skip over, and the honourable committee members can read for themselves. Then there's a reference to SAPS payments to accused 10 and 11, involving substantial amounts. And then it is alleged that there were gratifications. Accused 7 had many meetings with accused 5, accused 1 and accused 12. The majority of the meetings took place just after cash withdrawals, followed by calls between the various parties, followed by the movement as per cell tower towards a common destination. So, General, I'm not going to take up further time, as I indicated. The honourable members can read this for themselves. I thought we'd go through this a lot quicker, but you have now acknowledged that you face these charges and that you'll be going to court in October, November. Now, the other matter that is also before the court, this time the High Court in Pretoria, is a matter where you are again accused number 5. The charges are fraud, accused 5 only. Second charge of fraud, also accused 5. Third charge. Contraventions of the Public Finance Management Act. And again, there's charges of corruption, money laundering, and as you will know, General Phahlane, both as a service officer of SAPS and as an accused, the material facts are set out in the, and this is what you yourself wanted to talk about, but of course when you wanted to and at your own pace, and I've tried to deal with it up front as soon as possible. And this is the procurement of the software for social media monitoring during the Fees Must Fall campaign. During December 2016, the Division Crime Intelligence of the SAPS embarked on a process to procure software social media monitoring. The Division Crime Intelligence had been aware of the need to procure software for social media monitoring for a considerable period before the initiation of the procurement process in December 2016. The fees must fall protest started in October 2015. The process to procure the software for social media monitoring was initiated by accused 1, 3, and 7. One, 3, and 7 were not members of the component or unit division. Crime intelligence that was tasked with the responsibility of procuring goods and works for Division Crime Intelligence. Then there's reference to someone who has testified before us, Brigadier Shlungwani. On 21 December 2016, accused 3 called Brigadier Shlungwani to his office. Accused 3 showed Shlungwani a procurement proposal compiled by accused 1. The procurement was for the procurement of social media monitoring software. The social media monitoring software was meant to monitor and collect intelligence on individuals who were involved in the hashtag Fees Must Fall protest. Shlungwani recommended the procurement by indicating that funds were available for the procurement. Accused 3 approved the procurement proposal. I'm just apologies, Honourable Chair, Honourable Members, just trying to scroll through this quite quickly. A contract was awarded to accused 2 and 6. The price accepted by the Division Crime Intelligence was for 33,858,000. The system was known as Daedalus, D-A-E-D-A-L-U-S. It's a voice intelligence system, is a counterintelligence measure. And this is what the material facts allege about you, General Phahlane. Accused 5 failed to notify the Auditor General and National Treasury about the approval within the prescribed period, calculated from the date of approval of the application for deviation or any other time thereafter. So again, General Phahlane, just for the record, you are being charged in the High Court on a number of these charges. You are aware of it. Accused 5, acting with a common intent with accused 1, 3, and 7, submitted the annual financial statement in respect of the Secret Service account and the Division Crime Intelligence. Accused 1, 3, and 7 omitted to disclose the expenditures relating to the procurements of what is referenced as RIPJAR, R-I-P-J-A-R. I suppose you'll know what that means. And Daedalus. The purpose of annual financial statements, which must be submitted by accounting officers of organs of state, is to present a true and fair view of the department's financial performance, financial position, changes in net assets and cash flows, and other material disclosures. Then there's reference to accountability. And then it's alleged that there was a failure to report irregular expenditure incurred by the Division of Crime Intelligence. It's alleged that you had a duty to account to the executive in charge of the Department of Police, National Treasury, and Parliament. It's alleged that this constituted irregular expenditure. So, General Phahlane, before I move on to the next topic, your comment, and then we can perhaps move on.
Thanks, Chair. I'm going to respond to this question, or not the question, because there is no question there. Charges were read, which I'm allegedly facing in some courts. Now, I'm very much confused. One moment, I'm in a Pretoria Special Commercialized Crime Court. I thought that was the court where I was, where we were dealing with the issue of software. But when counsel starts reading, he starts reading to me what is sitting in the blue lights, which is in the court where he was representing Danny Jordan, Palm Ridge. That which you were reading, the blue lights, is in that court where you went to, Palm Ridge
I know that.
Special Commercial Crimes Court. Now, in that court, we deal with the blue light. Since you ventured into the blue light, and you are reading charge sheets that are supposed to be read to me by a prosecutor somewhere in court, I'm going to deal with what I was speaking to on the blue lights. And Honorable Chair, honorable members, it's sitting on page 133 to page 143
On a point of
of
order,
my
Chair.
affidavit.
Mkhalak,
I think General Phahlane is right. I really didn't understand what was happening. And I don't think he should even respond to that. He is entirely correct. I asked my colleague, what is this now? Because the question should have just been, are you charged in the commercial, what, and then leave it there. But to read him charges, like we're in court, we're the ones who are charging him. No, it's unfair. I think he must be protected from that. But equally, let's be conscious of time. I don't see how that is going to help us because we still have to attend to ask questions. General Phahlane is aware, if he's charged, he should be aware of his charges. And if there is anything that relates to our terms of reference in those charges, let's try and canvass that. And if it's uncomfortable, we'll say, I'm uncomfortable or I'm prepared to answer it. But to read him a charge sheet, no, it's unfair.
Honorable Sols.
Chairperson, just clarity. Did I hear correctly, General Phahlane is saying that the SC is one of the, of the counsel in the case that we are talking about? Did I hear correctly, or is it, what, did I misunderstand that? Just for clarity, please.
He was representing that line.
Not in this matter. He was just at the same court.
Yeah, they happened to bump at each other
Oh,
in the same precinct.
oh, okay, no.
Yeah. The point that you raised, Honorable Maluma, is sustained. Honorable Skosan.
Thank you, Chair. I think, Chair, for the sake of progress, this issue of court judgments and some General Phahlane is still going to appear in court. I think when we had this supplementary submission, I've read it as well. I think we have 900 and something pages, Chair, here. And I guess with the pace we are going on, like the issue of reading those judgments and paragraph by paragraph, Chair, we won't finish today. I understand that you allocated the evidence leader 2 hours. Maybe it's within his time, but
They have 42 minutes to conclude the presentation of evidence.
but we are not going to get anything as things stands now, Chair, because the way it goes is like we are reading. I concur that
look,
it's like we are in court.
If we don't, we will leave it to you members to ask the general questions that you want to ask.
Okay, thank you, Chair.
Chair. Sorry, my hand's been up.
Honorable Kola Barnett.
If I may, if I could have an explanation from the evidence leader, who seems to be, sir, who's not listening. If I could have an explanation from the evidence leader, it seemed to me, from a non-lawyer point of view, that he was indeed responding to the claims that there was no criminal charges, no action, there were no court matters. There were a lot of denials, and I thought that was what he was doing, was providing proof that in fact what he had claimed was true. So that's how I read what was being
Yeah,
done.
no,
If we could have an explanation on that,
We
please.
have long gone beyond that point. He himself said it on record here, that there is a matter before the cause. So now what we should do is to proceed. Let's proceed, Advocate Arendse.
No, but
Thank
Chair,
you.
was it not my turn to respond when I was, I think when Honorable
Oh,
Malema
he
raised issues?
he
Yes.
interjected.
I did not even start responding. And I'm mindful of the time, but in view of the charges that were read before me, at no point, Chair, have I never, at no point have I ever disputed that there were matters. And maybe let me not refer to the previous session. And I place on record the matters in court, which are two, the blue lights. Now, forget the confusion which is being created, whether it's Pretoria Specialized Commercial Courts or High Court. For clarity purposes, the matter of crime intelligence of the software started in the Pretoria Commercial Crimes Court. Now, that matter had to be transferred from that court to the High Court because the magistrate was conflicted. And what makes the magistrate to be conflicted? The very same Hlongwane that he's referring to was an accused in a case where there is 50,000 that was taken from the coffers of the Secret Services account. The complainant in that matter happens to be his immediate commander, who was Major General Namatonzela. Now, the magistrate who was presiding over now this matter where I'm in, because I'm in this matter with General Namatonzela, similarly presided in the Hlongwane matter where Namatonzela was a witness. It is on that basis that when it turned out later that there is conflict of interest from the magistrate and the matter is now before the Pretoria High Court. So it is one matter, Pretoria Special Commercialized Court, Crimes Court and the High Court. Now, if I am allowed just to deal with that matter, Chair, I'll come back to the blue light which he started going into. I'm dealing with the blue light, with the matter on the software. In page 144 of my affidavit, paragraph 330, where we talk about the Secret Services account. And I'm going to respond in this manner so that I'm not losing anything in view of how far the SC went. And this is not a yes or no answer. I deem it fit at this point to traverse the crime intelligence domain of the South African Police Service To the detriment of policing and service delivery by the subs, crime intelligence is subjected to vindictiveness, vicious attacks, public scrutiny by armchair critics and people who loosely engage with ulterior motives. This contributes to the destruction and destabilization which has become the embodiment of the environment in the South African Police Service. The prevailing environment of politicization, criminalization, disinformation, and weaponization of crime intelligence is not what was envisaged by our forebears in policing. I am premising my interface with the crime intelligence by focusing on select provisions of the Secret Services account and, in particular, the policy environment confronting the challenges. Now, I'm not going to go through all those. Chair, what is important here is that when we talk about crime intelligence, you don't talk of the same policies and prescripts that apply in the open account. If we go to supply chain management, it's an open account. If you go to finance, it's an open account. But the Secret Services account has got its own rules. Like I said, I'm not going to go through each and everything. First, in the Secret Services account, the law, not me, the law provides or permits for procurement based on a quotation basis. You simply could, if there is a need, those who may offer such services are to be approached, and the need will be expressed, and there must be a response in the form of quotations and so on, which will be considered by a committee. This happened in this particular case. We were having a challenge. Before I was appointed, the fees must fall issue was very prevalent. The Vuani banning of the 21 schools and so on was very prevalent. The absence of intelligence was a big issue. So the question was, how else can you source intelligence so that as the police we are proactively able to respond in executing our policing mandate? It is on that basis that crime intelligence, particularly people in the Secret Services account, embarked on a process, and that's when they obtained the quotations on this particular software. A committee in crime intelligence said that committee was the head of the Secret Services account leading, and amongst others, Brigadier Shongwani and so on, where they've considered the application for the software to be procured. Where do I come in? When they evaluated, it became clear that the quotation was way above their delegated amount. I think at that time they could only procure without approaching the accounting officer for 1 million or less. So this particular software, and by the way, here there is mention of 33 million. It's not one thing there, it's two things. It's a software which is social media monitoring, and there is ComSec. Both are included, it's not just one. So once they evaluated the quotations and found that this is outside their scope with the amount, the law say they must approach the accounting officer for a deviation. It is at that point that an application for a deviation was submitted to me, which I considered favorably and responded to them. There is your approval. You are permitted to do procurement beyond 1 million. That's where my role starts and ends. I'm not sitting on those committees. I'm not evaluating anything in that regard. I grant that. Now, allegations are you were sitting on the bid specification, you were sitting on the, BEC and evaluation and so on. Now, those must be explained there in court. The same Brigadier Hlongwane who was before this committee is a signatory to that application for procurement. And I was listening to him when he was here. He said, no, he was only issuing a financial authority. That thing is here. It's part of the document. See if there is an endorsement to say funds available. Because they did a round robin amongst themselves as committee members. That's why they did that particular approval. Now, I had no business to be reporting to anyone because the law say the secret services account, not even the divisional commissioner supply chain management, they will report where there is a deviation. Now, the person who was supposed to report is the head of the secret services account, not the accounting officer. Now you have got a very decorated charge sheet there where they say, Phahlane failed to report to National Treasury and so on. I invite those who say so to go and read the law and to familiarize themselves with what I at least try to do and place it in this affidavit 144 until 145, paragraph 333. And then I'm saying in paragraph 332.3, on 10 October 2017, McBride wrote a letter to the Minister of Police, Mr. Fikile Mbalula, stating in paragraph 2 and 3 of his affidavit that there appears to exist a corrupt relationship with Major General Nematunzela, Major General Machele, Lieutenant General Phahlane, and the service provider. The state allegedly suffered a loss of 33 million for a system which was hastily procured without proper procedures being followed. In stark contrast, the unit responsible for media monitoring source quotation for only 7 million. And I'm saying there my emphasis. Now, even today, I want to see that 7 million thing. There is no such. The very same docket that the SC is talking about is unable to produce this 7 million quotation. Instead, they produce something which they say it was a quotation to develop something that was forwarded to supply chain management. So that is in as far as what is it, REPJA or Dilateras or whatever, software and ComSec, where only Phahlane comes in because he is an accounting officer. He approves the deviation. And I say it and I'll say it again. If I have to approve that deviation today, I will do it for the sake of our country. Because that was to ensure that we generate intelligence to proactively respond to the issues relating to the fees must fall, and Vuane. And I think I've said it many times. I'm happy that no one died in that process. And I can still repeat and say, had the police had a software similar to that, maybe we could have saved the July unrest, because it was about the absence of intelligence. Now, Chair, I'm responding to the second issue, but before I move there, I'm saying my response comprehensively as it is, not to the charge sheet, because I'll deal with the charge sheet where it belongs, which is in the courts. And I was under no illusion that I'm coming to court here. I came to Parliament before the Honorable Committee where I'm to respond to the issues. Page 133 to page